now only we are going to the most important area, which is giving us 6 important freedoms. How to remember these freedoms? If you see these freedoms, they all emanate from which article? Article 19. Given to whom? It is given only to the citizens. This is all common things, okay, which I need not elaborate. But how to remember this Article 19? You have 2 ways. One is by naturally knowing how these started, by understanding. Next is by using acronym. First way we will start. Okay. If a small baby is born, what it will do first? First, it will cry, right? What is crying? Expression. It's type of speech, right? So first clause talks about 19 clause 1. Okay. Then these are all sub clauses. Don't write 19 clause A. There is no such clause. It is 19 clause 1, which gives 6 freedoms to you under each sub clause A, B, C, D. Okay, you understand. First one is crying by the child, which you can see a form of expression. So first freedom, why these freedoms are given basically is that Article 21 gives you life, but enjoying the entire life to the fullest is possible only via Article 19. So these freedoms are associated with enjoyment of life. Okay. So first one is crying, which is freedom of speech and expression. Immediately after crying, the baby will associate itself with the mother, right? So it is something association. You go and meet someone, you associate yourself. So this expression holds 2 freedoms to you. One is to assemble peacefully without arms. That is your associating, coming together. That is what is assembling. Okay. Next, you form associations per se. You assemble, then you get together. So 2 freedoms are there. Next, the baby will start to crawl. Okay. Crawl is nothing but making movement. So D clause is about Article 19 clause 1 clause B is for freedom of movement. And next, it will settle down somewhere. It will crawl, go sit somewhere. So reside, settle down somewhere. You move somewhere around India and settle down there. Reside there is also your fundamental right. So 19 clause 1 clause E gives you this right to reside and settle in any part of India. Once the baby sits down, what it does? It starts to play. Okay. Play with what? Some property, some toys. So this is associated with clause F, which is a right to property. Right to property was once our fundamental right, but now it has been omitted. Okay. Next, it has been placed as a constitutional right, but that's not important to us. So we'll leave this right. Next, after that, see, it will grow up later and then starts getting pocket money from its parents, right? Why I'm telling the story is to make you remember the order. Okay, you need not confuse with the clauses. That's why. Okay. So the baby is grown up. Maybe she's going to a 10th class. She'll get a pocket money from her mother, right? So final right is a right to practice a profession, carry on trade and business. So it is associated with economy. That's why I gave you this example. This is for basic understanding. But if you're very keen about using acronyms, you can use this word SAAMRPP. Okay. SAM RPP. Okay. What is this? Very simple. First one, S stands for freedom of speech and expression. Then A stands for freedom to assemble peacefully without arms. Second A stands for freedom to form associations and or unions. Okay. Then you have the M, which is freedom to move freely, not throughout the world, it is throughout India. So when you're talking about move freely, don't stop here. Please do mention throughout India. Okay. Next, you have R, which is a freedom to reside and settle down in any part of India, again, not throughout the world. Next, you have P, which is property, right to property, omitted. Next, the last P is to practice profession. Okay. For this, it stands for profession. Okay. 1 minute. Okay. Profession, which includes to carry on trade and business. So we have done all this. We are talking about how to remember your all the freedoms, 6 freedoms, which is given under Article 19. Now let's see about each and every article. Okay. what it is all about. Each and every clause. Okay, first clause is about freedom of speech and expression. You see this clause, it's a very, very important clause and mother of most of our rights. Okay, it doesn't only say about speech, it also talks about expression. It has given you two things. What is that? Why it has to be differentiated? See, speech is nothing but recognizable forms of sounds. Okay. See, I'm trying to hum a song, something like that. Whether that will be amounting to speech, it is not speech, it will be a form of expression. So, 19 clause 1 clause A recognize not only speeches but also unrecognizable sounds, which is a form of expression. So, when you're talking about expression, it includes a film, a movie, a dance, a picture, anything, choreography, anything for that matter. So, it is wide enough to cover any human conduct for that nature. Okay. So now we know this speech is not only confined about the form, it is also talking about a lot of mediums. Speaking online, speaking face to face, speaking before a lot of crowd, like doing an act in a cinema theater. So any form or medium it may be, like from mouth or writing or printing or picture, everything is covered. Okay, it is having a wide why I'm talking a lot about this? Because this has been asked in a previous year question. Okay. So now, if you see, this freedom of speech is not an absolute right. When I say it is not an absolute right, it means it has a lot of restrictions. Which article talks about that? Same article 19, but it is clause 2. 19 clause 1 gives you a lot of freedoms, six freedoms. And lately, after that, immediately, it starts giving you the restrictions too. In the name of what you can restrict these freedoms. First one is security of the state. Then friendly relations with a foreign state. Public order, decency, morality, contempt of court, defamation, incitement to an offense, which is against sovereignty, integrity of India, all these. So why I have given you 8 here? Because there are 8 restrictions. Okay. These are all not much important. Just have an idea. So we will quickly move. Okay. Next, you have the second freedom, which is freedom to assemble peaceably without arms. See, you take a lot of knives and you take AK-47 with you and you all assemble together and you say that we have assembled peacefully. Why you are like, why the state and police must be alarmed? Why are you coming? You cannot ask like that because it is a cumulative condition. The constitution is very wise. It doesn't stop here. Assemble peacefully. It necessarily says that you don't, your intention is to assemble peacefully. Apart from that, you shall not have any arms. So it is a cumulative condition. How important is this freedom? Very simple. You know that we have a parliamentary form of government. What do you mean? There, the parliament will be responsible all those things. In parliament, who are there? You have a ruling party and you have an opposition party. What these parties are made up of? They are any NGO? No, they are political parties. How they are formed? They are formed only by a assembly. They come together first and they form a union. And this union will be a political party. Then you try to, then they propagate using freedom of speech and expression. And then you vote, right? So now this freedom of assembly is so very important that it forms the essence of democracy and our party system. Okay, that's one thing. Next, you see the first freedom which we saw, freedom of speech. And this assembly has a close relation because if see 100 people are assembling, what they are going to do? Are they going to see each other's face and stand still? No, they are going to speak, they are going to express themselves. So the first freedom of speech and this assembling freedom is something related to each other. That's why their restrictions are also related. You have 3 restrictions only when you count verbatim, but there is a scope for adding other restrictions if it is found to be reasonable. Now we have a question whether the right to strike is included in right to assemble or right to freedom of speech. In the state of T.K. Rangarajan and versus state of Tamil Nadu, it said there is no such explicit right. Okay, but there are lots of case laws which says that tactically there is a little bit of right to strike, all those things. But UPSC is not keen about that. So just know this concept. Next, see, you have the right to assemble, but you don't have the right to assemble in someone else's property. If I take some 100 men and go and stand in your backyard of your house, whether that will be fine, and I can say that I have the right to assemble, so I am coming and assembling in your house, something like that. No, it is not possible. Same applies to a government property. What happened here is that there was a unlawful assembly, something like, because it was not an assembly which got a permission to settle down. This type of assembly was conducted in a railway ground. Okay. So the railway board told that they must be dispersing from that place. But they came back with a statement that you are restricting my right freedom to assemble. So court told that railway ground is also like a private property. You cannot assemble there without authorization. Okay. So each freedom, I'm giving you a case law. Then we have the second freedom. This freedom is also closely related with assembly. Once you assemble, you don't be quiet, right? You have some 20 people here, or see, I see every 22 people here. You must be talking among yourselves, right? Maybe I think there is a private chat group also. If maybe I don't know. So if at all it is there, once you assemble, what is the human nature? It is to form associations and unions, talk with each other. So that's what is your next freedom. Again, this association is the lifeline of democracy, because these unions are the names which is given to political parties, right? So without these unions, there is no democracy at all. So it is so much important. Now, under what grounds it can be restricted? Under these grounds. Okay. Now we'll move on. Now, we have the next thing, which is the freedom to move throughout India. This freedom is essentially sprung from one particular word, which is the union. If you see Article 1, there is a clause, right? India shall be a union of states, shall be Bharat shall be a union of states. So it is a union, which means we are all one. So that's why on Article, yeah, tell me.
Ma'am, but if we have to go to some northeastern states, they say that you need a certain kind of a permit.
Exactly. I'll say you, they come under the reasonable restrictions.
Okay. Sorry, I was jumping up.
No, excuse ma'am. So now we call our India to be a union. That's why we have a single citizenship. If you go to US, you have dual citizenship. I have gone some time back. Okay, what happened is that they were even there were state restrictions within. So if you have a state citizenship somewhere, you don't get to enter the other state if possibly. Some small issues were there. Okay, so these issues were to be overcome by giving you single citizenship. But practically, that can be effectuated only by giving you the freedom of movement throughout India. Okay, so that's why we have this. And this freedom is closely related to your next freedom, which is freedom to reside and settle anywhere in India. If you're not allowed to go inside a state, then where is the question of settling down in that state? Okay, so these two are closely related. But again, as ma'am told, it is not an absolute right. It has reasonable restrictions in the name of two things. One is in the interest of general public, which in COVID situations, movement was restricted, right? So it is supported by this reasonable restriction. I told you situation one, right? It is justified here. But second one is interest of scheduled tribes. You have certain areas exactly in northeast which you cannot go. Even in Andaman, you have the Sentinelese Islands, right? You are not allowed to go, but if you go there, they will kill you. Okay. So those are the areas, names in which we can restrict your movement. Okay. Now we have an interesting case law, Ajay Kanu case. Okay, everybody would have come across this case and facing issues due to this case, because See, I don't like to wear helmet when I'm driving, but it is a very bad thing. I say myself, okay. What happened? One such person like me went to court and told that, see, you are asking me to wear a helmet, and I'm not free with that. I cannot drive properly. It is restricting my freedom of movement. How intelligent you see. But the court told that it is in the interest of general public and it is not directly affecting your movement, right? What you're wearing something which is for your safety and state is a welfare state nowadays. So it is not violating your fundamental right of movement. Okay. Next, we have the last one. Why I skipped the middle one, which is about right to property, it has been omitted, removed from there. Okay, we will go to 19 clause 1 clause, which is the freedom to practice profession and to carry on any trade or business. You see, this freedom to profession, each one will be defined, okay? What is profession, what is trade, what is business, but that is not the concern of UPSC. You will see what UPSC demands, okay? We'll go to the previous year questions shortly. So if you see, we know that India in the preamble have promised socialism. We told it's socialist country. Then why others must have the freedom to carry on business and trade? Because we have not taken a strict socialism. We have followed a mixed economy. It is not like Russia. Okay, it is not completely state-owned. So why we followed mixed economy is that we created a level playing field for the government and for the individual. They both we promise socialism in our preamble, but we follow a mixed economy, which means we allow the government entity and also the private individual to take part in the economy and build an economically stable nation. Okay, that's why, although we promise socialism, which means which will derail anyone from accumulating mass wealth. Okay, at the same time, you are allowed to reap the benefit of your own hard work. So it is a balanced kind of thing. That's why we have promised socialism and also given freedom of trade and business. But it can be curved under these heads. First head will be in the interest of general public. Yes. And the next head will be like, see, everything restriction, if you see, there won't be a word like a particular state can make laws, something like that. Okay, it gives you an open statement like state can make a law which is relating to professional qualification. That is only clearing UGC net, you can be a professor under the central government. Now you cannot call that to be a restriction on profession. Okay, that is one thing. Next, the state can monopolize any trade. Last class also we saw that in Eclipse we saw this statement, right? So there was a chat. Okay, thank you, ma'am. So now we will see the next restriction is that the state can make any business to be monopolized. Monopolized means only the state will take care of that business. No private party is entitled to do it. But this monopoly can be an entire monopoly or a partial monopoly. So that depends the whim and fancy of the state. I have an interesting case in Tamil Nadu, not an interesting case, but an interesting happening. Okay, you see liquor anywhere in India, it is something like even a private individual can sell it, something like that, right? But in Tamil Nadu, only the state can sell liquor. There is a name called TASMARK. Only these people will be selling liquor in Tamil Nadu. It is a monopoly they create. Why they created? Using this clause. Okay, I'm not here to comment whether it is right or wrong, but personally, I feel it's wrong. But what happened in Tamil Nadu is that there were a lot of people drinking the substandard liquors created by private people, and a lot of them passed away. They were all dead. That's why state monopolized it. Okay, so you die slowly. Why die immediately? That may be the thing. Okay, now there is an interesting case. This was a case in Madhya Pradesh. What happened is that there was some restriction placed on the liquor trade. Same in Madhya Pradesh. One person came in and stated that I have the right to take on any profession. Why are you restricting me? The court rightly stated that profession is there, but there is no fundamental right to trade liquor in the interest of general public that can be curtailed. This applies same to the essential commodities like milk, rice, all those food items. Okay. Now we have done. Okay. So we have done from entire Article 19 we saw. We have almost completed. So let's see the previous year question. Let's see whether you are able to answer those questions. That's very important. If you see the 2021, you have, they asked I think they asked, yeah, right to education was asked. Okay. If you go to 2018 only, they start with Article 9. Someone please ask, someone please read.
Ma'am, can I? The 2018 question, right, ma'am? Ma'am, can you hear me? I cannot hear you.
I can hear you.
Okay, ma'am. So, the liberty of the press, implicit in the freedom of speech, stands on no higher footing than the freedom of speech and expression of a citizen, and no privilege is attached to the press as such distinct from the ordinary citizen. Explain the statement and also distinguish the terms speech and expression and competitive federalism.
Okay, you see how it is mixed up everything together. That is your first question. Next question. Someone read this 2013. Maybe Nitish sir, can you read please?
My voice get distorted in your mic.
Yes, sir. Please read, sir. Is commercial advertisement?
Is commercial advertisement covered within the ambit of freedom of speech and expression? Discussed with reference to leading cases.
Okay, sir. Thank you. Next question is about 2022. The next article. So we will skip that. This also we covered in right to information. Okay, we'll skip that. So someone, maybe I'll call Mudazir sir. Can you please read 2010 question?
Yes, ma'am. Whether right to vote is a fundamental or a statutory right. Justify your statement with the help of relevant case law on this subject.
Okay, so next 2009 question. Someone please. Madhu ma'am, please. Yeah. Please read, ma'am. Yes, ma'am, I can hear you. Please read, ma'am.
The in one has been held in information and in the context of media industry is the of the Constitution of.
Okay, ma'am. Thank you so much. Thank you so much. So if you see all these questions, whether you're able to answer that with this lecture, you see how UPSC has transversed from the syllabus. Yes, these are from the syllabus with the heading fundamental right. Okay, you can imagine where UPSC is concentrating. So here 19 clause 1 clause A is very important. That is freedom of speech. When you talk about freedom of speech and expression, in that there is a particular area called as freedom of press that have been repeatedly asked till now. So now freedom of press is most important. Whether there is a specific provision for freedom of press in Constitution? No. If you see the US Constitution, there is a specific mention about freedom of press in Amendment 1, First Amendment. Okay. Someone has put me a chat. They told that my voice is breaking. If you're able to hear me clearly now, put me a word in chat. Let me continue. Today, there's a lots of issues, right? I'm very sad regarding that, but we'll continue. Okay. So there is no specific provision for freedom of press in Indian Constitution for that matter. There is a specific, yes, ma'am, it is wobbled. You're able to hear me now? Now it is audible. Okay, thank you, Pratika ma'am. So now if you see, as you see, there is First Amendment which gives you, there is freedom of speech to the citizen and also freedom of expression and speech to press. It have been specifically mentioned. But Indian Constitution, the freedom of press is taken from Article 19 clause 1 clause A only, which gives everyone, the citizens, the freedom of speech and expression. Why we are very particular about that? Because see, from here only freedom of press comes. So every person, every citizen have the same freedom, and the press also enjoys that same freedom. It doesn't have any special privileges. Okay, so when it is not having any special privileges, it doesn't have any special restrictions too. So if citizens' freedom of speech can be restricted under these heads, only under that head, the freedom of press can also be affected. That's what it means. It has been asked in your UPSC. Okay. If you take this freedom of press, it is like a triangular right. First one, you have the freedom of expression. Okay, expression. From this, you get the freedom of press. Okay. Then, from this freedom of expression, you get one subtle right. What is that? You can express only when you know something. We already saw, right? It has a right to know. To support this right to know, we need freedom of press. You understand the triangular formula concept which supports each other. So if you write all these things in your answer will have good connectivity. Okay. Now, if you talk about the freedom of press, its importance have been given in a lot of case law. One such case law is Prabhu Datt versus Union of India. They have been told that right to know news and information is very, very important for a government to function, that too in a democracy. That's why 19 clause 1 clause A includes freedom of press too. Okay. So now we have this fundamental right. But before the fundamental right, whether this freedom of press was recognized. Yes, it was recognized in the case of Channing Arnold versus Emperor. This is a Privy Council case. This you can use for the introduction. Okay. Now we are talking about freedom of press, freedom of press. But the major area which we must know is how much this freedom of press is protected by our constitution. That have been asked thrice in previous year. Okay, we'll see how it is protected. First, you will be giving how all those things
Ma'am,
are. Yeah, tell me, sir.
ma'am, on this triangle,
One minute, sir. 1 minute. Much issue.
the third component is right to know. This is respect to us. It is citizens' right to know, or
Sir, your voice is bit of like breaking. You can right to know whether it is citizens' right to know or right to know. Press.
yes, ma'am.
Right to know, again, it is common for press and for citizens. So
How for press?
how for press? There is a case law, sir, which we will be seeing after 3 slides. There we will discuss about right to know of press, sir.
Okay.
Okay. I'm very happy you people are asking questions like which is more related and intrinsic to the lecture. So I'm really happy. Thank you for the question. So now we'll see how far it is protected. Okay, freedom of press. We have a very important case law, Sakal Papers versus Union of India. Why this case law? It is just for the statement. This statement. In this case law, it has been stated that freedom of press is regarded as a species, means a small area, of which a freedom of expression is a genus. So freedom of speech and expression is a big family, and this freedom of press is a small member of it. Why this statement? Because UPSC is very famous for statement-based question. Okay. Now, I told you, right, sir, freedom of press. What that freedom includes? Whether that freedom includes only expressing myself like printing or saying something or writing something, or writing a letter or creating a newspaper and having it with me? What is my extent? That was given out in two cases. First case law, Ramesh Thapar was a state of Madras. What happened is that, see, I am a press person. My name is A. I am printing this newspaper and coming to a state and trying to publish it and circulate it. But suddenly the government says that I cannot circulate this paper in this area. Whether it is affecting my freedom to expression, because they did not say that you shall not print, you shall not create a newspaper. Nothing was said. They told you don't publish it here, you don't circulate it here. That was the restriction. Whether it is affecting my expression, freedom of press, the court told yes. In this Ramesh Thapar case, it happened that there was an English journal called Crossroad, and it was held restricted from publishing and circulating in Bombay. They initially told cannot be printed, but later they amended. Okay, so the court told Article 19 is a wide area which includes the freedom to access information, the freedom to publish it, and the freedom to circulate it. In this case law, they relied a lot on freedom of circulation. So we have the next case law, which is closely related. Union of India versus Association of Democratic Reforms. Facts are not needed because we see a lot of case laws with a lot of facts. So let's omit certain facts, which is not much important. For this case law, you must know that freedom of press includes all these three things. So you asked me, right? Freedom of acquiring freedom, like right to know how press is having it by the normally saying the free right to know. It is common to everyone, being the citizen. Every citizen have right to know, and press is no exception. But specifically, it has been stated in this case law that freedom of press includes all these three things. Okay, so hope my your doubt is clear, sir. If you have other doubts, please put it in the chat. We will go to the next case. See, we saw no one can say don't publish, don't circulate. But whether you can fix a fixed number of pages for a newspaper. You can only see Hindu must be only for 10 pages, not more than that. Whether government can say that. Definitely not. That was given in Sakal Purpose versus Union of India. Very, very important case law for freedom of press. Try to include it somewhere if it is related to your question. Okay. What happened is that you have this daily newspapers price and page order of 1960. This order specified a fixed size or page for newspaper for a given price. This was held to be violation of Article 19 Clause 1, Clause A, because why it is violation is because the ground is nowhere justifiable under the 19 Clause 2. Okay, don't get confused. Freedom here, restriction here. Okay, there is a chat again. Too many questions. Someone is putting that they'll be very happy if Hindu is restricted to 10 pages. Yeah, even myself. Okay. So, but it cannot be done because it is violating 19 Clause 1 Clause A. Okay. Now we'll go to the next case law. Bennett-Coleman case is a very important case again. It says that for the fixed number of pages, see, government initially what they did is first they tried to bring in fixed number of pages for fixed price. Okay, 10 rupees only you can print so much, something like that. It was related to the price. Okay, but later what it stated that we will fix the number of pages because the smaller newspapers can flourish. If you are putting all the news, what the smaller newspapers will have. So that was the argument. Even the court told next time also it is still violating your Article 19 Clause 1, which is freedom of speech and expression, freedom of press again. Okay. Now, we have the next question. Interesting question. Okay. Yes, the newspaper gives lots of news, but what it also does is giving advertisements. Okay. You see a lot of institutions giving advertisements in Hindu, right? We got AIR1, AIR2, something like that. Whether those advertisements is protected under 19 Clause 1 Clause A which is freedom of expression. It was a huge question, because why you advertise? Because I want to attract a lot of customers. So it is something related to my business, whether is trade or business, whether it is related to my expression. There was a huge question. But we have a major case law. So this statement verbatim asked in UPSC whether advertisement is protected under freedom of speech. Okay, very hard question it was earlier. Okay, but it will be made easy now. So you see this case law, Tata Press Limited versus MTNL. Okay, in this case law, the court ruled that commercial advertisement is protected under freedom of speech. You have the ratio decidendi here. What is the ruling? But what is the rationale for this ruling? That must be written. See, any question asked, you give the facts of the case, you give what is held. Okay, you are good. But explaining the rationale, why it was given so, will increase the coherence in your answer, the connectivity, and that will give you more marks. Simply mentioning 5 case laws, 6 case laws, good, you will score more in LLB examinations, but not in UPSC. Try to rationalize every legal point. Every legal point is nothing but a logic. Okay, so now we'll go. You see, earlier advertisement was regarded only to attract consumers, all the customers. But now you see it is a way of spreading information so that public become aware and benefit from that information. You may ask me how that is true, how that can be done. Very simple. See, I was like, what's wrong in this? I can say that. See, if you are having cramps, menstrual cramps, mostly women will take pills. I used to take pills too. But latestly in advertisements, I came to know about this heating pads. Okay. These heating pads can be placed anywhere in your body, your head or something like that. Okay. This is treating all sort of cramps. Without advertisement, I will not be open to these types of things, right? Maybe your phone too. See, if there is no advertisement, you will not have a choice. So what this advertisement is doing? One, yes, it is promoting business, but on the other hand, it is giving you information. If it is giving you information, then what it is? It is a freedom of speech and expression. That's first rationale. Okay. Next, I'll go to the facts of this case, then you will understand the rationale even more higher. Okay. You have two companies. One is the Mahanagar Telephone Nigam Limited. It is a government company. And then you have a private company, which is a Tata Telecom Limited. Okay. This Mahanagar company was given like license for conducting telecommunication business, and also it was licensed to give out information on phone numbers of that locality. You have seen this book in your when you were young. I have seen it when I was in first standard, I guess. So my father used to have this book, and he used to call VIPs, maybe the commissioner, or see anybody in the electrical department if current goes off, from seeing this book. So this book is called as the Yellow Pages book, and it will contain all the important phone numbers of that locality. Even my father's number was there. Okay. So anyone can take this book and locate and call that person. That is the reason. This not only contain the information, it will contain the advertisements too. So this Mahanagar Telephone Nigam was publishing these numbers. They have the exclusive license to publish these numbers, and also they were distributing it using contractors, and these contractors were allowed to make white pages. These white pages contained a lot of advertisements. Okay, that's how they earn and circulate. That's what going on. But suddenly the private player came in and he started to publish Yellow Pages. Okay, this was same like that one which was done by Mahanagar Telephone Limited. He also published all the telephone directory, everything. What today Just Dial do? That's what have been in the printed form. Okay, that's what is Yellow Pages. So when a private player started and doing this, the Mahanagar company came in and filed a case against them. They are crossing the license. They are not the licensed person. What the court told? The court told this information, what they are giving, is important to public. So it is a commercial speech. Just because a businessman is expressing his speech or expressing his idea, doing expression, he cannot be removed from article from 19 clause 1 clause A. He is a citizen, right? So his expression in any form, maybe in advertisement, that also is protected. So this private person, apart from having license or what, license was not taken into account, so he has the complete right to disseminate such information. That was the rationale. So how you are giving a rationale, whether a public commercial advertisement is protected under freedom of speech? First one, yes, it is protected. Why it is protected? Because the advertisements is a form of commercial speech. Why it is a commercial speech? Because our citizens are informed about each product and they can make rational decisions. So it is a commercial speech. That will be your second point. Third point, just because a businessman is expressing his thought, you cannot cull out it from the protection. He is also a citizen. Now there is a hinge. If the businessman is a foreigner, whether his advertisement will be protected under one clause A, he will not be protected. So being a citizen is very important apart from being a businessman here. Okay, so that you have to know. Here we have another case law. Hamra Davakna was Union of India. Same proposition accepted, but here, there was a test, something like that was devised. They told that all ads are not something which is protected under the freedom of speech and expression. There will be two types of ad. One ad disseminating info. One ad is solely for trade purposes. So if an ad is solely for trade purposes, that will not be protected under 19 clause 1 clause A. If it is disseminating info, it will be protected. Why so? Because there was a law which was passed to curb ads, which was obscene, which was offensive, and which is against morality and decency. The court upheld this law and stated that any ad which is promoting only trade, that can be curtailed. Okay, so that was the ruling. But you have another case law which is Circle and Bennett together. Yeah, tell me.
Ma'am, when it comes to these ads, and you're saying that if it is promoting trade, then it will not be coming, or it will not be falling under the article, right? Hello, ma'am.
Tell me, ma'am.
Like, ma'am, is my understanding right?
Can you please come again?
Ma'am, you said that if at all an ad is promoting a trade, then such kind of ad is not fall. It will not fall within the article.
Yeah, it will not be protected in the freedom.
It won't be protected under the article.
Yeah, it won't be protected.
So for that, ma'am, can we take the example of the tourism ads?
Tourism ads. Yeah, you have certain ads. Okay, see, a liquor bottle will come in and there will not be any info. It depends upon the type of ad. Tourism, they say this place is very good and you have all the infos of the place, something like which is educating you, and you are able to choose which place you can go. That is giving you information. You understand? So you cannot strictly say these ads are only trade purpose.
So,
These
ma'am, because if we see recently, the government has made this Rajasthan tourism it into a commercial activity, and it has subsidized and it has cut down the taxes and all of that. But apart from that, if you see the the tourism ads, they're both informative, and it is actually bringing in some sort of an activity also. So that's why I
Yeah,
question
it will be protected. If it has information, it will be protected. Clause 1, clause A. There was a good question from Nilot Palam, I guess, someone. Very good question. He asked that, what if it is not protected under 19 clause 1, clause A? But can we seek protection under 19 clause 1, clause G? Yes, you can seek protection and it can be restricted under those reasonable restrictions. You understand? I hope you got my point. So there
Yes,
are,
ma'am.
yeah, ma'am. Thanks. So we will move along. Yeah, earlier
Ma'am,
point. Yes, sir. Who's it, sir?
ma'am, can you please explain what is the exact difference between freedom of speech and expression?
Yeah.
Why I'm asking is that the Supreme Court time and again has differentiated between freedom of speech and expression. Can you please tell us what exactly is speech and what exactly is
What
expression?
is speech and what is the difference between expression, right, sir?
Yes, ma'am.
These two different. So practically speaking, I come with concept and I then give you case laws. First one, speech is nothing but see, sounds that are understandable. If you talk a language, that is speech. But if you are very angry and you shout, whether that's speech, that is an expression. Okay, both are sounds, but speech is a recognizable form of sound, which is recognizable in terms of language. But if you see expression, it is also a sound, it includes sound. Speech is also an expression, sir. Expression is a wider area, but specifically the article gives expression. Why is because it includes see, your painting, everything. You now you remember the Copyright Act. You write something, that is included. Newspapers, you see, it is not speech, it is an expression. And you dance, that is an expression which is not speech. So practically this is a difference. And there are, I think there is one major case law too. I will put that case law in the chat, sir. Where they'll be explaining or listing out what all expression and what all speech, sir. Got me, sir?
Thank you, ma'am.
Thank you, sir. So we will move on.
Hello, ma'am.
Yeah, ma'am. Tell me.
Yeah, just for clarification, moving back to the Bennett Coleman case, was it held that the maximum number of pages can be fixed or it cannot be fixed?
No,
I
no,
just
no.
wanted
It
to know.
cannot be fixed. It cannot be fixed.
Even in the Bennett Coleman case, it was held that.
Yeah,
it can be-
yeah. It was. See, they tried to in under Bennett Coleman. What they tried to justify is that small newspapers are not able to thrive. So bigger newspapers must be restricted in pages. So that was a different practice. Here also it was held. It is still violated. In MP chain we have this.
Okay, ma'am. Thank you. Thank you.
Yeah. Thank you. So now we'll jump back quickly to the Suckle papers and Bennett Coleman. Again, they have done an important thing. What it is, in the earlier case, there was a distinction drawn between the commercial ads and the ads which are giving you infos, right? So this differentiation was diluted later in this case. It stated that the commercial advertisements cannot be denied protection under Article 19 clause 1 clause 8 merely because it is from the businessman. So there is a classification, but it is little bit diluted. So now it is for the court to decide whether they want this classification or not. It is an open question. Okay. So remember this because open questions are favorite one for UPSC. So you have to give your own rationale. Understand? Now, see, imagine you are going to Bihar jail, not as a convict, okay? So you're going to Bihar jail to interview a jailer, a prisoner. And this prisoner is not a small person. He has been convicted for death penalty. He's a death row convict, okay? Whether you have the right to go and interview, because you see, there is freedom of press. And I told you the freedom of press has the right to know, get information. Now, whether this right to know helps me, whether allows me to get inside the jail and get the interview of a death row convict. It was a famous case law, Srimati Prabhadat versus Union of India. The court told, yes, it is your fundamental right, provided the prisoner must be willing to give it. See, you have the right to get the information, but he has this right of privacy, right? So when it clashes, right of privacy goes higher. And if he is willing, you can go and get the interview. And this interview can be stopped by the superintendents of the jail. It is given under the rules, these rules, 594 clause 4 of the Manual of Superintendence and Management of Jail Provisions. Why I am giving this rule? Yes, it can be stopped by the superintendent, but he must give a written reason for denying the same. That was given in this case law. Okay. And that reason must be very heavy. Okay. If you see this has been explained, so this is all you can read and understand. Okay, we will go again. Now, you see, newspapers and books, something like that. See, newspapers can publish anything. Interview can be of anything. Whether they have complete freedom or they can be coming under censorship. What is censorship? Censorship is nothing but removing the inappropriate areas from your information, from your written format or something like that. Closing what is not required, which is not inappropriate, you close it. That's what is censorship. Okay. Whether that can be applied on a newspaper or an interview, any news channel is getting the interview, whether it can be censored. That was a question. Okay. What happened is that this is a see, this exact fact has been asked as a problem-based question in UPSC. So please do listen. We complete quickly. Okay. There was a TV program in Doordarshan on what laws relating to women. This lady was asked to come and give her opinion, where she criticized a bill which was pending before the parliament to be violative of women's right to equality. What Doordarshan did? Doordarshan, you know, right? It's the government's TV. So whether it is going to publish that, no, it deleted that remark and published in the TV. Now this women got antagonized. Really, it would be right. It is her expression, but it was denied. So she went to court and instituted a case stating that it is violated her right to speech and expression. The court came, but the other party, that is Doordarshan, told that it is not a censorship. We did not delete by way of, we doesn't want to delete it, but it is only editing because the interview was very long. You see how intelligent the court rightly took hold of it, saying that interviews and newspapers cannot be allowed to pre-censorship. Why? Because see, newspapers and interviews are done, interviews of giving you information, something like that. Okay, not like cinema interviews, all those things. Okay, interviews giving you information, something related to press, newspapers. Okay, that cannot be pre-censored because see, why we have newspapers? To bring in something which is under dark, like scams, the real identity of the government, especially the ruling party. So pre-censoring or allowing censorship on these things is definitely curtailing the freedom of press. Okay, it will affect our democracy in return. That was the thing. Not only censorship, the deliberate distortion of any views would violate your Article 19. So you are asked to give your views, which happens basically in this debate shows and all, right? In South India and Tamil Nadu, we have a debate show called Niya Nana. Whatever they speak, most of them will be edited. So that is again violative of Article 19. But editing is allowed. But distorting your speech and giving some other information. You say that this bill is violating your fundamental right and this bill is good. You give the good part alone. That is distorting your freedom of speech and expression. That's not allowed. Okay. So now we saw what, yeah, tell me.
Ma'am,
What is it? Tell me, sir.
Ma'am, censorship is actually deleting the unwanted speech in the newspaper.
Yeah.
What is actually meaning of pre-censorship? Suppose if someone give interview, how the pre-censorship is done?
Okay. Censorship, censorship is something normal. Okay, sir. You have two things, pre-censorship and post-censorship. Post-censorship is not mostly happening. For live interview, censorship is not possible. But they come to your place, take the interview, or it can be telecasted later for later purpose. Then if it is censored and it is put, it is called as pre-censorship, sir. You understand me, sir? Live only it
Okay.
cannot be censored.
Okay.
Yeah.
Thank you.
So yes, sir. Thank you. So now post censorship is something different. Okay, we don't have that concept here. So pre-censorship is what we mean by censorship. Censorship means removing. Pre-censorship is before publishing I remove it. That's what is pre-censorship. For interview it cannot be done. Whether for newspapers pre-censorship is allowed. We have a case law, Birji Bhushan versus Delhi. There was a very famous magazine called The Organizer, run by Birji. Okay, this was like disseminating a lot of information about Pakistan and war and their officials, all those things. If at all they were giving out some atrocities about Pakistan, I don't say Pakistan is doing atrocity. They were giving out all those news. Okay, at that time. So what happened is that the Punjab government started to give an order saying that this newspaper magazine is a threat to peace and order. So they must send the duplicate copy to the government first. And after getting approval, they must publish the same. But the court told it is affecting the freedom of speech and expression. So no free censorship for press. Okay. But whether pre-censorship is there for films, anybody can answer?
Yes.
Yes, it is there. Many of us would have seen this notice, right? It is a certificate for each film. If you see, there is a U or a A. U means underage. Children can watch. A means it is adult movie, which is not like, see, children cannot watch, something like that. Okay. Censorship is allowed to films only. Why it is allowed so? There is a rationale. You have a case law, A.K. Abbas versus Union of India. It stated that films shall be treated separately from other expressions. Why? Because these motion pictures have a different capability to stir up emotions more deeply than a newspaper. You read something, see, you read a case about a Nirbhaya case, you read something, but there is a film about Nirbhaya. Which one will be affecting you, Lord? The motion picture, right? That's why it must be censored. First thing. Then my personal opinion, okay? If you see a film, why film is like films are produced? It is for entertainment. But sometimes they are used as a tool to educate people too, no doubt. But basically it is for entertainment. But why press is there? Press idea is to create awareness. So if you stop this awareness area, it is going to affect you. But entertainment, it can be affected and like restricted in the better way to stop obscene things, to stop which is not required. For press, for daily newspapers, where is the time to come and pre-censor it? Because everyday news is printed at nights and morning. So there is time constraint too, and the ideology constraint too. Okay, that's my basic opinion. You can use it for conclusions. Okay. Then you have the same point given in another case law. Again, it has been stated that this all these films are communicated to the mass audience and it has a unique capacity to disturb and arouse feelings. That's why it must be pre-censored. Okay. Now we have only 2 case laws to finish off. Okay. We saw that fixing the number of pages of a newspaper is violating your freedom of press. Whether like getting allowances for government ads in the newspaper is violating your freedom of press. Yes, the court told it is ultra virus, because what happened in this case, Hindustan Time case, 5% of the like for publishing any ad, you must pay some amount, right? From this amount, 5% must be given as an allowance to the government ads, and this 5% will be used to provide pension and social security to the scheme of senior journalists. That was the idea. It was a social development scheme, but this was not allowed by the court. It told that see, advertisements are the basic income for the papers, right? If you stop or lessen their income, it will affect the printing. circulation and publishing. So it is directly affecting freedom of press. That was the first point. Next, whether fixing minimum wages for the journalist, something like that, for the betterment of the labor, something like that, whether that is affecting freedom of press. Now the court awakened and stated that this is too much. So any law which is prescribing working hours, minimum working hours for the journalist, gratuity or minimum wages is not violating your Article 19 clause 1 clause A. Why? The basic idea of this law is to give you betterment, that is for your welfare. Okay, it is for the labor welfare. So like any other profession, press is also one, so they cannot escape from the general welfare laws. So that was given in this case law. Express newspapers versus Union of India. You have the exact rules, the name of the rules is given here and told that this rule is valid. Okay, so tax laws you say, and general laws which is applying to other profession too, it applies to press too. It is not a violation of freedom of press. And there is a question whether levying of custom duty is affecting freedom of press. Note down this question because it's important. I'll come to that. Okay, now you see all these area, you feel like I'm going somewhere out of the subject, right? Because our topic is fundamental rights, and in that I am talking about Article 19, and now I am talking about the minimum wages of a journalist. See how far UPSC is gone. These were the areas where UPSC is asking question. So from where all I got these information? You think from internet, from any other place? No, it is from the MP Jain standard book. You see this topic, verbatim questions, verbatim statements from MP Jain have been asked. So after this class, I'll put 5 pages. Okay, so I'll ask someone who's having the latest version of MP Jain to put these pages, scan these pages, only 5 pages, and please go through these pages. Next question will be from only these 5 pages. Okay, and the latest issue is about right to vote. You see this issue, Nawab Malik and Anil Deshmukh. Who are these persons? They are a Congress leaders. What happened?
Maharashtra.
Yeah, yes, sir. You have the latest version of MP Chain, sir.
No.
Okay, sir. I'll tell you the page numbers in the chat. Please do take photographs of that and make a PDF and put it in the WhatsApp group, sir. Can you please do that, sir? Oh, you don't have, sir. Okay, I'll do that then. If anybody is having, please tell me in the chat so you can do that. Okay. So what happened? These two people are the Congress party leaders. These people are placed under the judicial custody. Okay, and they want to participate, cast vote in the Rajya Sabha election, but they were not allowed. They now say it is a violation of my fundamental right. And see, the lower court did not allow. So they have filed a petition in the Supreme Court, which is pending still now. So what is right to vote? Whether it is a constitutional right, statutory right, or a fundamental right. We have different opinions. In 2003, in the case of People's Union for Civil Liberties, Union of India, it was stated that it is a fundamental right. Right to vote is a form of expression under 19. Okay, so it is a fundamental right. But if you see, Article 326 only says that there is universal adult suffrage, and using that, the parliamentarians and state legislature can be formed. So whether it is from Article 326, if it is from Article 326, it will be constitutional right. Okay, it is not a fundamental right. Fundamental right alone can be, if it is violated, you can file a writ. It is a constitutional right, you cannot file a writ. Okay, under 32. Then there is a famous act called as Representation of People's Act, which entirely takes into hand the election, all those things. Under 62 of section 62, there is a right to vote, and section 65, there is a restriction that prisoners cannot vote. So whether right to vote is a statutory right? So this is the next question. And if you see, We have a latest case law touching upon this point is Puttasamy versus Union of India in 2017. What this case law is famous for?
Right to privacy.
Yeah, exactly. But in this case, it was also told that right to vote is a statutory right and it must be soon made as a fundamental right so that it is kept away from the reach of the legislatures. So there is an open question that whether right to vote is a constitutional right or a fundamental right or a statutory right, which is yet to be answered by a Supreme Court. And this can be your latest mains question or the next mains question. Okay. Now, if you go back and read all the previous year's question, you will be able to answer them. Yeah. We have completed. Like any doubt, tell me.
Ma'am,
1 minute, sir. Tell me, sir.
am I audible?
Yes, sir. Tell me, sir.
Ma'am, coming to pre-censorship, we have seen that an woman who has given an interview regarding the bill pertaining to rights of a woman. What newspaper has done that he pre-censor or curtail the interview part and publish it. Then he goes to court and stated that he has violated my right to freedom of speech. But recently we have seen that many MP MLA has made a statement regarding the prophet. Can he can suppose there is a religious interview is going on and the newspaper who is conducting the interview for not who is conducting the interview and the MP MLA who has given their statement which entails may create the law and order situation. Can in this situation his interview would be pre-censorship? Suppose in
Yeah, it can be done. It can be done. I told you, right, sir. It is a right protected under 19 clause 1 clause A. So it is it has a restriction.
because it is also an interview, no?
Yeah,
That's
yeah,
why.
yeah. If it is justified under the restrictions, it can be done.
Okay, so ma'am, next question. What do you mean by self-incrimination? Because there is a question in 2009, scope the right with regard to self-incrimination.
Yeah, sir. Self-incrimination comes under Article 20, sir. And 2022 will be taken together. That have been see if you see the previous year question that I have put earlier, sir. 19, 21, 2022 together in one box we have created. So that's why this question comes in. Right against self-incrimination is the next class.
Okay.
Yeah. Any other doubts?
No, thank you.
Yeah. Ma'am, could you please share the MPJ book number? Yeah, I will share it in WhatsApp chat. Thank you, Pratiksha, ma'am. I will count on you. I will put it in the WhatsApp chat and please do take photographs and put it there. Why I am not doing is that because my pictures are not coming out clearly. That's why. Yeah. Any other doubts?
Yes, ma'am.
Last.
Ma'am,
Mentions of case laws regarding subclasses B to F, ma'am.
Oh, Krishnamurti, sir. Please ask, sir. Tell me, sir.
Ma'am, can you please tell some case laws regarding subclasses B to F?
B to F. Sir, there are a lot of case laws, sir. If you go through the revision notes, there are a lot of case laws. But read that once if you would like to. But UPSC is not going to ask them. You see the entire 30 years paper too. There is no single question, sir. Please go through the revision notes. You'll have, I have given two case laws in each thing. Now in the slide, I have given one case laws. In the revision notes, you have actually 2 case laws each, sir.
Okay, ma'am.
Yeah, sir. If you want specifically me to teach extra case law, if you would like to, we can have a separate class. But sir, that's wasting your time.
Ma'am.
Yes, sir. Tell me, sir.
There is a question. It is open for the state to curb monopolies and prevent concentration of economic power. But when such legislation has direct effect on infringing the freedom of press, then such legislation is required to be declared invalid in relation to newspaper industry.
Yeah.
Discuss. My question is coming to the monopolies and concentration of economic power. Is it regarding to advertisement? Because is they creating the monopoly
No, sir. It is
by
creating monopoly in test, which means, sir, you put this question. What I
yes,
do
ma'am.
is I'll solve it and I'll put it. See,
Okay, ma'am.
this is like, see, this is like a, problem, that is a issue between the freedom of press and the power of the government to monopolize trade. So you see,
Yes,
there
ma'am.
is a conflict between the first one clause A and the final one clause G. So how far the restriction can curb the first right? So it is coming out, this restriction monopoly is not affecting only the trade and business. It is coming again and directly going and affecting the first freedom of speech and expression. So you can see the restriction given under one clause G, which can curb only the profession and trade, cannot curb your first right.
Okay, ma'am.
You understand, sir?
Got it.
The
Yes, ma'am.
restriction
Got it.
given monopoly is only for trade, not to restrict the freedom of speech. So that will be the direct discussion, sir.
It
Case law we
it
have.
simply means that if a state will curb monopolies, it will hamper the freedom of speech and expression.
It cannot hamper so, because that is not the reasonable restriction given under 19 plus 1 plus 2.
That's why there should
Yeah.
not be monopoly.
Yes, sir.
Okay.
Yes, sir. Exactly. Yeah. I see two hands raised. Someone can, first person, Varda ma'am, can you please ask?
Ma'am, I just want to clarify the right to vote, ma'am.
Yeah.
So, ma'am, basically, right to vote is not a fundamental right, but it can come under as a right of expression. Is that it, ma'am?
Yeah. See, ma'am, it is an open question. I have put you three areas supporting each one thing. If you call it as a fundamental right, yes, you can call. How you can call is by this case law. This case law says that the right to vote is a form of expression which is protected under 19 plus 1 clause. Like right to know. You understand? It has been interpreted in such a way. And if you're saying statutory right, you have this People's Representation Act. And if you're calling it as a constitutional right, you have this article. So it is up to you, because the court is silent, right? Yet to say. So it is up to you to give a discussion.
Yeah. Thank you, ma'am. Thank you.
Yeah. So another person has raised the hand, I guess, but I don't know whom.
Yeah, ma'am.
Manasa, ma'am. Tell me, ma'am.
Yeah, even my question was regarding right to vote only. I got some clarity, but as of now, we have a precedent of 2003 case only that right to vote is a part of fundamental rights. Right?
We have some 8 to 9 cases, and there is a recent article in June 29th, I guess, by the leaflet. Okay, that article is very nice. I'll put that article in the chat. So that article will discuss everything. Because of the time constraint, we are not able to talk a lot. Now also you see only 18 people, and 16 people is only there. So that's why I'll put that article there in the chat.
Okay, like whatever will be decided in the Puttaswamy case, we can take that for the exam paper.
You
But
can
if it is
take that
at all,
for discussion, because it was not a ratio decidendi. It was, I mean, like it was not something like your sad decisions. It was something a corollary discussion. So you can like, take it as a supporting view. It is not the final point.
okay.
Yeah.
Okay, as of now, like the latest thing that we have is what you said is June case, right? June 2020.
Yes, 2003 is the direct case law.
Okay, that is better to refer.
Yes, ma'am. But don't omit Puttaswamy
Okay.
just for discussion.
Okay, fine. Thank you, ma'am.
Yeah, fine.
And ma'am, one more thing. You were saying that levy of custom duty, whether violation of Article
Yes.
9.
Yes.
What about?
We have 2 points. General tax, when we are talking about newspaper, is not new, but custom duty, there is an exception. This you're going to find out from the 5 pages of the MPJ that they are going to put. These 5 pages are most important. Most of them are covered here, 90% covered here. One point I did not cover is this customs and this tax thing. Okay. So please read every paragraph. This 5 pages, make a short note and keep it. Okay, I keep this open for your exercise.
Sure, ma'am. Thanks.
Thank you, ma'am. Manasa, ma'am, doubt is cleared. Okay, someone else? Any doubts? Varda, ma'am, again, do you have a doubt, ma'am? Okay, I'll take. There is no more. Varda, ma'am is having a doubt. Tell
Yes,
me.
yes, ma'am. Yes, ma'am. Ma'am, could you please explain the Puttaswamy relation again, ma'am?
Yeah, Puttaswamy versus Union of India. It is basically about your right to privacy. What this court held in this case is that right to privacy is protected under Article 21. So that is the decision which is having force. Okay, if you say take a decision, a ruling, there will be two parts. One will be called as arbiter dicta. Another one will be called as a stare decisis. Ma'am, you are aware of this? You're a law
Yes,
student?
ma'am. Yes,
Yeah,
yes, ma'am.
okay,
Yes,
then it is very simple why I go there. So stare decisis point is that right to privacy is under Article 21. But this thing, which is about right to vote, is a statutory right. It was something like a arbiter dicta, which was a small discussion about within the court. Okay, so it doesn't have any legal force. It is only a discussion, which you can use it in your answer discussion, like supporting. Even judges are saying these things, something like that. Okay,
okay, ma'am. Yes, ma'am. I understood.
that's an
Thank you.
info.
Thank you
Yeah,
so much.
right. Because there are a lot of law students and non-law students, so that's why I come from the instruction. Okay, any doubts, you can let me know. Okay. Thank you so much for staying. We'll wind up.